first like to quickly apologize for the change of date of this session and thank you all for being flexible and being able to tune in today. It's lovely to see you all. My name is Jeff Collins. I'm the Business Development and Marketing Manager for Dowling WLG's Waterloo office. Our discussion today promises to be an exciting one as my colleagues Bettina Burgess and Hina Gauss will walk you through all things HR professionals need to know about COVID-19. And before I go over some housekeeping items, I just wanted to take a moment to update everyone on the status of our new office building at 345 King Street West in downtown Kitchener. We are really excited to get in there. And actually you can see Hina is actually in there today, which you can see by her lovely blue background. We are currently finalizing the construction on the interior of the building, but we do look forward to being able to welcome you into our space. We are looking forward to welcoming you into our new space within the next couple of weeks. So please look forward to that. And if you haven't seen it in person, please feel free to drive downtown Kitchener, or you can look in my background right now and there's a little shot of it. Today's presentation will be recorded, and hopefully we've managed to both pin the presentation and the speakers correctly so that their boxes fill up the main parts of your screen. If not, there are some controls, I believe, in the right top hand corner of your screen and where you can adjust the layout yourselves. We have muted everyone and we'll ask you to keep your microphones muted during the presentation to help eliminate any background noise. There will be time at the end of the presentation for you to come off mute and ask any questions that you may have. If you prefer to write your questions in, you're certainly welcome to do that using the chat function. Just please make sure you're either sending them to all participants so that I'm able to see them, or directly to myself, Jeff Collins. Lastly, we will be sending a copy of the presentation afterwards, as well as posting the full webinar on our website. So please feel free to put your pens away, sit back and enjoy. As I will hand it over now to Bettina to take us through today's agenda. Thank you. Bettina, you're currently on mute as well right now. Chantel, when she mutes everyone, she mutes everyone.
Okay, can you hear me now?
Perfect.
Okay, there we go. Of course, it would be me who has the first technical glitch. Thanks very much, Jeff, and good morning, everybody. It's so good to be connecting with you all. It's been probably almost 2 years since I've done a presentation for a big group of people since COVID started, and I was just flipping through some of the names of the people who have joined, lots of people who I've missed over the past couple of years. And I know COVID has been so terribly hard for everyone. It's amazing that almost 2 years later, we're still talking about it and giving presentations on it. Of course, the latest and greatest is everyone's thankfully going to be returning to the office for the most part, or back to work for those who have been cloistered at home forever. And so now we're dealing with a whole lot of new issues about vaccination and workplace safety. And I can tell you that there are so many challenges that people have faced. And almost a year ago, a little over a year ago, I was diagnosed with an autoimmune disorder that rapidly developed to the point where I was pretty incapacitated, and I had to take about 5 to 6 months off of work to recover. And thankfully, due to really fabulous drugs, I was able to get better, but they're immune suppressant drugs. And so this has given me a whole new perspective on COVID and the things that all of us are facing. And while it hasn't necessarily impacted the advice that I give to clients, because of course that's all based on very objective legal analysis, it has enabled me to have a better perspective as to the dichotomies that you guys are all facing as HR and employers, and having to deal with people who have very different personal situations that all come into play when it comes to COVID. So what we're hoping to do today, Hina and I, go through sort of where we are now with COVID and how what are your lives going to be like as HR professionals and employers as people move back into the office? So Hina's going to start by going through what the vaccination and workplace safety requirements are across in Ontario primarily, but you'll see that our slide deck has information for every single province across Canada. But we're not going to go through that during the presentation. It's just there for you to look at later if you need it, if you happen to have employees in those other jurisdictions. And of course, we can help you outside of the presentation if you need help there. Then we're going to talk about the human rights exemptions that are available with respect to vaccination. Hina's going to go through some case law. We don't have a lot right now, but we've got some across the country that has dealt specifically with C19 issues. And then we're going to describe some ways that you can mitigate your liability in terms of dealing with return to work, vaccination, and rapid testing. And then, of course, Q&A. So now I'm going to turn it over to Hina Gauss, who, by the way, is one of our most recent additions to the employment group in Waterloo. She's a fabulous associate. I am lucky enough to be her formal mentor, and she's a wonderful mentee. Hina is, I believe, 4th year. Hina, correct me if I'm wrong.
Going into 3rd year.
Okay, well, you practice as though you're at a 4th year level or above. Anyhow, welcome, Hina, and please, at home, give Hina a little round of applause, and off you go, Hina. Thank you.
Thanks, Bettina. So today I'm going to cover what the vaccination requirements are mostly in Ontario and in the federal sector. And then, like Bettina said, there are slides for the other provinces that I won't go through, but they're here for you to see when you need to. So in terms of what the vaccination requirements are in the federal sphere, the government of Canada will actually require employers in the federally regulated air, rail, and marine transport sectors to establish vaccination policies for their employees. So what this means is airlines and airports, as well as other organizations who have employees that enter these restricted areas, would be covered by these vaccination policies, as well as federally regulated railways, which would cover rail crew and track employees. And then there's also marine operators with a certain amount of people on their crew. So in terms of the vaccination requirements federally, there is a short phase-in period where there's an opportunity for everyone to get vaccinated, but eventually each organization is actually required to guarantee that employees are fully vaccinated or they'll be unable to work. And there will be exemptions for reasons such as medical reasons or religious reasons. But right from the get-go, the government came out and said these kinds of exemptions are going to be granted in the most rarest of circumstances. So that's sort of where we are in terms of the transportation sector. In the public sector, there is also a mandate that applies. So individuals need to be fully vaccinated by a certain date. And if they don't comply, they could be subject to an administrative leave without pay. So the mandate for the public sector, it applies for the public service in Canada. But that being said, the government has made it clear that it expects Crown corporations, the National Defense, and other similar institutions to follow this similar mandate. So that brings us to the private sector, and what's happening here is all over the place. Different organizations have their own types of policies. Some are more strict than others. Very early on, we saw that a lot of the major banks came out with their vaccination policies, and it's just, there's more every day. There's the Canadian Blood Services, Canada Post, a couple mines here and there. So, you know, the private sector, it seems like there's new policies coming out regularly. So next slide, please. So that was the federal sector. And in terms of Ontario, what you'll see across the provinces is fairly similar in the sense that there's only mandates for populations or frontline workers that work with vulnerable populations. So for example, in Ontario, we have sort of a mandatory vaccination requirement in long-term care homes in particular. So this would apply to all of the in-home staff, support workers, students, and volunteers. They're required to be vaccinated or show proof of a valid medical exemption. And if they have this valid medical exemption, then there'll be requirements to undergo rapid antigen testing, usually a couple times a week. For the long-term care sector, I think it's at least once every 7 days. So that's, there's no health sector wide mandate, but it is for specific populations. Then in terms of the public sector, the government or the Chief Medical Officer of Health actually released a directive called Directive Number 6. And it applies to things such as hospitals, ambulance services, home and community care service providers. And all of these covered organizations under the directive are actually required to establish a COVID-19 vaccination policy that requires full vaccination. So again, there are people that can be medically exempt, and if they are, then they're going to be required to undergo rapid testing before attending work. So those are the main directives and sort of guidance that we have. In schools, there's no, like, students are not required to be vaccinated for COVID-19. Teachers mostly have to disclose whether they're vaccinated or not. And if they're not vaccinated, they need to undergo, again, that rapid testing. And it varies very much in the private sector. One interesting thing about Ontario is that it came out with a regulation that requires businesses and organizations to comply with any advice or recommendation or instructions that come from the Chief Medical Officer of Health. So if the Chief Medical Officer of Health or his or her medical officers in consultation with him say you need to develop a COVID-19 policy for your workplace, you're supposed to follow it. And since this regulation, a lot of different medical officers have been coming out recommending that various employers do have a COVID-19 vaccination policy. So next slide, please. So here, there's a couple of slides just covering the other provinces that you can go over whenever you have time, but I won't go into them today. But there are similar requirements throughout, with people working in vulnerable sectors usually required to have some sort of a vaccination policy for those employers. So I think.
Okay, yeah, sorry, Hina. I think it flips over to me now. So one of the other requirements, as Hina indicated, we have to comply with whatever public health organizations are recommending. One of them is screening. And we've had a few questions from clients recently asking, do we still have to comply with the screening requirements? And is it passive screening or active screening? And right now, the regulation in Ontario still requires active screening. And so the difference between passive and active screening, passive would be you have a list of questions that an employee would look at and satisfy themselves that they don't have those particular symptoms or conditions. They haven't traveled outside of Canada, that kind of thing. And then they enter the workplace. We're not there yet. Hopefully we're going to get there, but right now it's still active screening. So what that means is, as an employer, you are still obliged to ask certain questions of your employees and make sure that you know what their answers are. That doesn't mean that you have to stand there in front of them and ask the questions. You can do it by email. You can have a link where the employees have to go read the questions and then reply to you that I have no symptoms, haven't traveled outside of Canada, or however you have the questions. It's either all yes or all no, that kind of thing. But you do have to make sure that before someone enters the workplace, they are answering the screening questions. Ontario has just put out a new set of screening questions. So you don't have to follow those particular screening questions, but there's a tool on the Ministry of Health website, and you can actually use that if you haven't developed screening questions for yourself. And there's a link so that once the employees go through the screening questions on the Ministry of Health website. It can be emailed to you. Next slide, please. And Hina has just gone over that we do have a requirement that all employers in Ontario have to have a written COVID policy. I was surprised to find out that a lot of clients didn't realize that they had to have this policy and are now catching up and having one put together. What we are finding is that some provinces, and this will likely transfer into all provinces in Ontario, they're moving away from just COVID-19 policies to any communicable disease. Okay. So Hina's going to, well, we're going to start talking about, sorry, Hina, you're going to talk about religion and creed in a moment. The next two big issues that seem to now be in the forefront with respect to vaccination and whether or not you can ask for vaccination status, medical information, are human rights. And one of the things that we were really curious about initially was, well, what are the human rights tribunals going to do with this? Because we know that under certain circumstances, you're not allowed to ask for medical information. That in and of itself can be considered discriminatory under the Human Rights Code. And what do we do about people who don't want to become vaccinated for religious, creed-based reasons, medical exemptions, that kind of thing? Thankfully, next slide, please, Jeff. Thankfully, most of the human rights tribunals and commissions across Canada and in particular Ontario have put out guideline statements as to what they believe is acceptable with respect to COVID-19. And Hina, I'll turn it over to you to just give a brief overview of what the tribunals are saying.
Right, so what we have up here on the slide is what the Ontario Human Rights Commission is saying. And what they're essentially saying is requiring proof of vaccination at work is acceptable as long as there's protections put in place for those that are unable to be vaccinated for human rights related reasons. So they gave an example of someone who's unable to be vaccinated, having an alternative accommodation in place, such as rapid testing or COVID testing in the workplace. So this statement's really important because it does show that the Human Rights Tribunal and the Commission supports the vaccination requirement. It's not offside from the human rights perspective, as long as it takes into account persons that are covered by the code and accommodations for those. So next slide, please. So as Bettina mentioned, there's basically two grounds where an employee can claim protection under human rights legislation. So there's disability, and this covers medical, and then there's creed. So this covers things like religion. So I'm going to talk about creed in a little bit, but I think Bettina is going to cover medical disability first. So next slide, please.
Okay, thank you, Hina. One of the things that I was going to say in respect of the two, so as Hina mentioned, so far, no one has come up with any other protected ground under human rights. It's religion, creed, or medical exemption. So if an employee comes to you and says, I'm protected under the Human Rights Code, you can't ask me for this information, you can't require that I become vaccinated or undergo testing, then you pretty much know that there's only two exemptions that you have to worry about. If they try to suggest to you that there's something else, they're likely wrong. And even with the two exemptions that are available, they're very limited. So I'll talk about the medical exemption right now. They have to be pre-existing conditions. And the slide goes through what the Ontario Public Health Organization has publicized as legitimate medical conditions that a person may have preventing them from being able to be vaccinated. Anything other than these medical conditions, it's very suspect as to whether or not they really cannot become vaccinated. That doesn't mean, however, that you should be getting into a debate with your employee. But what I will say is when vaccinations first started becoming a big issue, and very recently as employers are now requiring them in the workplace, employees were turning up with notes from various clinics around Ontario who were just willing to write a prescription or a note for the employee saying this employee cannot be vaccinated due to a medical condition. What I would suggest to you is that you don't have to accept that. You still can't ask for the employee's medical diagnosis. So for example, you can't say, do you have thrombosis or myocarditis? But what you could require is that the employee return and get a note from the medical professional with the medical professional certifying that the individual has one of the enumerated conditions on the Ministry of Health website. And if they don't, then you could certainly go back and question whether or not they ought to be vaccinated. And you're in a good position to deny the accommodation on that particular basis. I want to make sure I've got all the notes. Oh, the other thing is the medical profession in Ontario, at least, has also now been advised by the Ministry of Health that they ought not be providing medical notes for employees indicating that they can't be vaccinated unless they do have one of these conditions. So hopefully we can start to trust a little bit more what we're seeing from medical professionals. Also, in terms of applications under the Human Rights Code, so far we haven't seen a lot of decisions from human rights tribunals other than determinations by human rights tribunals in other jurisdictions where they have a preliminary screening process, meaning that they can, the commission can kick out applications at an early stage because they don't meet certain criteria in order to bring a human rights application. There are a lot of applications that are being kicked out because, for example, there's no causal link alleged between the person's medical condition and the adverse treatment by the employer. What we can say, and so all of that to say that it's very, very unlikely that there are going to be many employees who are going to be successful in bringing discrimination or failure to accommodate claims based on the requirement to become vaccinated. There's a very, very small percentage of the population that will fit within the medical exemption. Unfortunately, though, thousands and thousands of people across the country are trying. And so the human rights tribunals across the country are becoming incredibly backlogged, and it's resulting in a delay in other types of human rights applications that are going forward because they're having to deal with this backlog. So just keep that in mind when you've got a different type of human rights matter that you're dealing with, and it's taking a year before you even get a mediation date. Okay, next slide, please. All right, so again, we're just looking at the medical criteria that is publicized on the various provincial websites. Oddly enough, every province has listed their own medical conditions that qualify as one resulting in an individual not being able to become vaccinated, but generally speaking, they're quite similar. All right, then moving on to slide 22, please, and then I'll turn it over to Hina.
Thanks, Bettina. So like Bettina explained, there's only 2 grounds right now that an employee can bring a claim under for COVID-19 vaccination. So medical disability is fairly restricted, but CREED is a little bit more complex. So CREED is actually not defined in the Human Rights Code. So it's hard to know exactly what is covered. What is covered by CREED has been developed through cases over the years. And so courts and tribunals often agree that religious beliefs and practices would fall under CREED. but there's also things that are non-religious belief systems that could fall under creed. So it's relatively nebulous compared to something like a medical exemption. But there are a lot of different factors that a tribunal would look at to determine if something falls under the ground of creed. I won't go through all of them today, but there's things like whether it's a comprehensive overarching system, whether it really deals with those ultimate questions of human existence, things like that go to whether something could fall under the ground of creed. The way it's been coming up in COVID-19 vaccination is some people have been saying that they can't be vaccinated due to their religion or creed. But there's very few religions that ban vaccinations altogether. There are a couple denominations that have a tradition of denying vaccinations or immunizations, but for the most part, they don't have a large following in Canada, at least. What we're seeing more often is that some people are saying that their creed or religion prevents them from being vaccinated based on certain byproducts or things that are either in the vaccine or things that were used in the development of the vaccine. So this is a harder one to deal with because although the vaccine doesn't contain a lot of these ingredients that some people are worried about, in the development and testing of the vaccine, there are certain things that are used in the scientific process. So if someone says, there might have been stem cells used in the testing of the process for vaccination in developing the vaccine, they might try to bring that up as a reason that they're unable to receive the vaccine. So these are sort of more complicated and developing issues. Another difficulty with creed exemptions is what kind of documentation do you have to ask for and can you accept? It's not as straightforward as a medical or disability exemption where you're going to go to a doctor or nurse practitioner, they're going to give you a note and what it's going to essentially outline. In terms of creed, there really is no standard set of documentation that you're going to be looking for. So what we've been seeing is people going online and finding something, printing it and saying, this is my creed, and this is the reason that I can't be vaccinated. And so this is why a lot of employers, HR professionals are pushing back on the type of documentation that employees are bringing, because you can challenge it to an extent, especially if there's a good faith reason to believe that it might not be valid. So this is, again, a pretty complicated area. And if one of your employees brings up the ground of creed, it takes a bit of an assessment to see if this is something that's valid or not valid. So next slide, please. Luckily, the Ontario Human Rights Commission has tried to add some clarity to how the ground of creed might be affected in the COVID-19 context. So the Human Rights Commission came out and said that personal preferences and singular beliefs are not protected under the ground of creed. So we see this all the time with people just specifically not believing in the COVID-19 vaccination for a variety of reasons. The tribunal has said that if someone does not want to be vaccinated based on something like a personal preference, that doesn't fall under the Human Rights Code. And so an employer is not required to accommodate that employee based on their preference. So that's a really important statement from the tribunal, knowing that what is and is not covered under the ground of creed. A lot of the other commissions across the province or across the country have come out with similar statements. I know there's been one in Alberta, in New Brunswick. They all generally echo the fact that a singular belief is not protected under the relevant human rights legislation in their province. So next slide, please. So like Bettina said, the tribunal is fairly backlogged at this point, just getting cases heard. So a lot of the cases that we have seen so far are just the masking cases that have now made it to the tribunal and now have a decision. So one of the earlier cases that came out is Sharma in Toronto City, and this one came out in 2020. This was a case where the applicant refused to wear a face mask when he was going to several different stores around Toronto. And And the applicant said that he alleged that he was discriminated against at these various stores because of his disability and because of his creed. So the way that the applicant actually described his creed is he said, "My creed disagrees with covering my face for unsubstantiated claims." He said that his creed requires that he doesn't blindly accept what the government or agencies claim and make into laws. He said that it was part of his creed and part of his civic duty to be critical of the government and its decisions. So after this explanation, the Human Rights Tribunal found that the ground of creed was not engaged. This was more of like a singular belief or a political opinion that just didn't fall under that sort of comprehensive system that you would need to fall under the ground of creed. The applicant also brought up his disability as a reason he could not wear a mask. And the tribunal found that the ground of disability was engaged, but the applicant actually tried to bring an application against the city of Toronto because they're the ones who have the bylaw. But what the applicant really should have done is brought a claim against the parties that were actually, he alleged, were discriminating against him. So these various store owners or stores across the city, but he didn't do that. So because he named the wrong party, ultimately the tribunal dismissed his application. And so yeah, just dismissed his application. And this was one of the earlier cases that really after this case, a bunch of other cases came where applicants were claiming creed or they were claiming disability that the tribunal just quickly dismissed. The tribunal found that in a lot of these cases, the ground of creed just was not engaged. So here is another case from this year. It's called Dubé and Dutch Love Cannabis. This is another mask wearing case that also involved creed. So the applicant explained his creed to say that he has a belief that requiring wearing a mask does harm to him medically, physically, and spiritually. Again, the tribunal found that this didn't fall under the ground of creed, and I posted a paragraph here on the slide that actually refers back to the Sharma decision, basically saying that the applicant here, he disagreed with a health mandate, and having a philosophical disagreement doesn't amount to engaging the ground of creed under the Human Rights Code. And this reflects the theme that you'll see in the tribunal say all the time, that the tribunal doesn't have the jurisdiction to just deal with general allegations of unfairness. The unfairness has to be connected, at least in part, to one of the grounds that are specifically set out in the code. If the unfairness can't be connected to one of the grounds in the code, likely discrimination will not be made out and the tribunal will dismiss the case. So next slide, please. So those were some of the Human Rights Tribunal decisions that we've been seeing in Ontario. There's also been a little bit of case law that's now coming out across Canada. One of the cases that got a lot of attention recently is Blake and the University Health Network. This was a case where unvaccinated workers at a Toronto hospital, they actually asked for an injunction and they didn't want to be terminated by the deadline that they had to be vaccinated. So they went to court, they asked for an emergency injunction, and they actually got an injunction for about 6 days. Justice Dunphy granted this temporary injunction until they could actually have a preliminary hearing on jurisdictional issues. Could the judge actually make a decision here? So they were granted an exemption for about 6 days, and then they went back to court, and ultimately the court lifted the injunction and said, you know, he doesn't have the jurisdiction to deal with this sort of thing. What's really important about this case is that Justice Dunphy explicitly said at the beginning that I am not ruling on the vaccination policy or its validity at the University Health Network. He was specifically dealing with the issues of an injunction. So it is a narrow decision, but it is one of the first ones that we have. So, you know, we're watching it and keeping an eye on it to see how it develops. So there's also been other legal cases that are coming out. There's been constitutional challenges that are being brought by various advocacy organizations. For example, the Justice Center for Constitutional Freedoms. They recently launched a challenge against the province's proof of vaccination mandate, so the vaccine passports. Next slide, please. There's been a couple other injunctions in other provinces across Canada. So in Quebec, there's been a challenge in the context of healthcare workers. In Saskatchewan, the province was actually successful when persons were challenging their proof of vaccination policy. The individuals didn't get the injunction that they were asking for because the Saskatchewan government found that the policy was in line with legislation and the charter. So we see that these sort of constitutional cases, these injunctions are slowly coming in, and the trend seems to be that the policies are doing okay for now. But again, it's very early days and we're still waiting for more information and more guidance from the courts and tribunals. So again, on this slide, I just have a couple more cases. There was another constitutional challenge in British Columbia, and there was also a ruling in Manitoba this year about the province's public health orders, and they were found to be they were not found to be unconstitutional, and they were found to be okay. So like I said, these cases are still coming in and they're slowly starting to trickle in, but we'll see. It looks okay for now, but we'll see what guidance the courts and tribunals provide to us. So if there's anything else Bettina wants to add to these cases, otherwise I'll just turn to her for the next part.
No, thank you, Hannah. That was great. I think what we're starting to see is a trend towards acceptance of vaccination requirements across the country. And I think for a lot of us, we're starting to have a great sigh of relief, just wanting to know one way or the other, what are we supposed to do here? So it's wonderful that we're starting to see some decisions come out. So now just getting into some practical day-to-day issues, questions that we're seeing from clients as people are coming back to work and we're developing vaccination policies and things like that. Many of you, if you have implemented vaccination policies in your workplace, you might have received one of the lovely notice of liability letters that someone has either crafted themselves, an employee has crafted themselves, or they've gone on the internet. We have had clients who have received the very lengthy ones that seem to be passing around on the internet that cite violations of every piece of legislation under the sun, from the Human Rights Code to the Nuremberg Charter. And what we tell our clients at first, because they're alarming, because they have in big bold letter, we're going to hold the company liable, and you as the HR professional who's enforcing the policy, we're going to hold you personally liable for all of this. Don't get frazzled. It's a bunch of bunk. There are, of course, legitimate legal issues associated with requiring employees to become vaccinated, but the vast majority of the stuff that is contained in these letters is just inflammatory and it's wrong. Despite the fact that it's wrong, you shouldn't ignore them. You have to engage with the employee in a discussion about why the vaccination policy is in place, the merits of the vaccination policy. And a lot of times what we're finding is that people have become so militant about their personal rights, which isn't a bad thing, but they're not actually reading the full contents of the policies that their employers are implementing. I would say that the vast majority of policies that have come across our desk, or the conversations that we're having with most of our clients, is that yes, they have a vaccination requirement, but they also have a rapid testing requirement for those who don't wish to become vaccinated, or for those who cannot become vaccinated. And I'll get into that in more detail. So for the individuals in your workplace who are coming in, presenting you with one of these notice of liability letters, it's a matter of educating them on the steps that can be taken within your policy. The other thing that we're watching as legal counsel are the bulletins, the blogs, the articles, the newspaper articles that are going out there primarily from the plaintiff side bar, because we as defense lawyers want to see what is it that our employees are being told and what are we going to be facing as lawyers in terms of arguments that plaintiff counsel are going to be making as litigation starts to ensue over vaccination issues, which for sure it will, as employees start to become terminated, laid off, things like that. Surprising for most of us in the Ontario Employment Bar, Mr. Howard Levitt, for those of you who have heard his name before, seems to be on our side in terms of helping employers send a message to employees that employee, you're going to have a very hard time bringing a legitimate claim against your employer who's trying to enforce vaccination or otherwise occupational health and safety measures to keep the workforce safe and the general public safe. So but that doesn't mean that the entire plaintiff bar is on that side. We still have a lot of plaintiff lawyers out there who are indicating that they will absolutely go for the jugular for employers who are trying to implement vaccination policies and who take adverse action against their employees, such as layoff, reduction in income, or termination of employment. And we'll get into those issues very shortly, but just to give you an idea of what the plaintiff bar is indicating out there right now. So let's talk about mitigating liability with respect to vaccination policies. Most of you, every employer should have one, really. It's like any policy, although vaccination policies are not always mandated in every single province. Policies are always a good idea to have because it sets out for the employee in very clear language what the expectations are, what the processes are, and what the consequences are going to be for not following the policies. In terms of whether or not you should be requiring vaccination of your employees, yes, the trend is full vaccination, but you should only require it of employees who are actually going to be physically interacting with those either in the workplace or outside of the workplace. If you have an entirely remote workforce who are never really going to be interacting physically with one another, or you have sectors of your workforce who work from home permanently and not just because of COVID, there's really no reason to require vaccination. And so if you were to take adverse action against those employees for failing to become vaccinated, you could absolutely face liability in terms of changing terms of employment, not in the human rights realm unless they have a legitimate protected ground, but overall with respect to wrongful dismissal, constructive dismissal, things like that. Whether or not you implement a full vaccination policy should not be dependent on whether or not you can have workers at home. So let me put it another way. You don't have to offer remote working to employees who do not want to become vaccinated for reasons other than medical or creed religion reasons. You are entitled as an employer to require your employees to come to the workplace, even though for the last 2 years it's worked fine with them working at home in front of their computers at their kitchen table. You're still allowed to say, no, we expect you to come back to work. And as a condition of coming back to work, you must be vaccinated. That is not without risk though, and we'll talk about how you can potentially mitigate that risk as well. And that is offering testing. So how we kind of look at this in terms of liability is in tiers. So if you require full vaccination and you have to be fully vaccinated in order to come to the workplace, you really have to be able to justify that. Having legislation backing you up helps. like in the healthcare industry or at the federal level. Or you have to have the type of workplace where individuals are going to be working in close proximity with one another, and rapid testing as an alternative just isn't a safe way to proceed. That's the advice we're giving right now, because unfortunately we don't have any decisions from the courts yet or the labor board as to whether or not truly full vaccination requirements are going to be permitted without any repercussions for employers. So if you can offer rapid testing as an alternative, do so, because that will reduce your risk of liability to your employees for changing terms of employment or unilaterally imposing adverse consequences on the employees for failing to become vaccinated. What a lot of clients are doing, and what we're advising some of them to do right now, once you initially issue your policy, even though this has been coming for a long time and many employees have known about it, they still need time to get their minds wrapped around the policy, particularly if they have not become vaccinated yet. So you can give a deadline, the date by which an employee must become vaccinated. If they don't, if you can, rather than just outright terminating their employment, place them on an unpaid leave of absence. That's the next step down in terms of liability. You can let the employee know that during this time, we may need to engage in a recruitment process to replace you. Be as transparent as you possibly can with them so that they know that there may be a consequence for them and you're not just going to have them on an unpaid leave of absence indefinitely. And continue to keep them updated. Okay, we found a candidate. We're giving you the option now of becoming vaccinated so that you can return to the workplace. Otherwise, we may have to go ahead and hire this individual. Again, it's not foolproof. It's not a guarantee that that's going to eliminate your risk or liability, but it's another way to show that you were making best efforts and doing everything that you could to save this individual's position before ultimately terminating their employment. So the concept is that every alternative that you provide to the employee and they refuse those alternatives. So for example, if you offer rapid testing as opposed to vaccination and they still refuse both, then you're in a much safer position either to place them on an unpaid leave of absence or even to terminate employment for cause, because you've offered very reasonable alternatives for them. All right, next slide, please. Sorry, Jeff, you had actually moved ahead. Can you go back to the rapid antigen testing slide? Okay, rapid antigen testing. I'm sure a lot of you know about it. I have just cut and pasted the language from the Ministry of Health website that describes what rapid antigen testing is. So you can have a look at that. And that is something that if you have employees, if you're offering it and employees are concerned about what it is, what does it do, you can direct them to this website. Okay, we can go to the next slide. If you are going to implement rapid testing at work as an alternative to employees becoming vaccinated, the testing should be done on site. It can be done at home, but you don't know whether or not the employee is doing it properly if it's done at home. And it's also going to require the employee to bring in the test, and they might forget. It just adds a layer of, I guess, logistical problems for you. So it's best to do it on site at work. There are training videos that you can watch on the Ontario Ministry of Health website to train someone in your workplace who can oversee the administration of the test. You can also allow employees to do it on their own at work, but they should watch one of the training videos as well for conducting a self-test or doing it themselves. If at all possible, you should have a room set aside or a screened off area where employees can go and do the testing. It's suggested that you have staggered times for doing the testing so that it's not required as soon as everybody gets into work or you're gonna have a big lineup. The testing can be done as many times as you want during the week. It's recommended that it be done 2 to 3 times a week, but no less than once a week if you're relying on that to screen employees who are unvaccinated. The other thing to keep in mind is that because the tests require a nasal swab, the test kits themselves are considered biohazardous waste. And so if the testing is being done at work, or if you're collecting the kits with the results on them, they have to be disposed of in accordance with the Environmental Protection Act. And there's a link there on the slide that shows you where you can go to get information about how to properly dispose of the test kits. We are often asked, well, who pays for these kits and who pays for employee time while they're undergoing the testing? There's really no excuse for employers requiring employees to pay for rapid test kits if they make this a requirement under their policy, because every province in Canada is offering free test kits to employers. On the next slide, I believe we can, no, I forgot to put it in. Sorry, you can go back, Jeff. We can send out the link, but if you go to, if you just Google, how do I get free test kits? You will be able to find a link or on the Ministry of Ontario website where you can apply for free test kits. Now in Ontario, there are conditions and strings attached to getting these free test kits. Some provinces just give them for free. Others require you to engage in studies and things like that and have conditions attached to getting the free test kits. But all of that to say, so long as they're free, you're really not going to be able to charge employees for it. Again, we don't have anything yet legislated on that point, but I would imagine that there would be a successful complaint to the Employment Standards Branch if you started requiring employees to pay for their kits. In terms of the time it takes them to do the testing, again, it's our view that if they're doing it as a term of employment because the employer is requiring it, it's work time and it has to be compensated. Okay, next slide. Okay, some of the other questions that we're getting often is, well, what exactly can we ask for from employees with respect to their vaccination status and their test results? Because it's medical information, many employees feel very uncomfortable about disclosing it. And we as employers don't really love having to collect this information and store it and be liable for it as well. So what are our obligations? Well, this depends. This varies depending on the province that you're in, because this really is about privacy laws. And of course, we don't have federal privacy legislation that governs provincially regulated employers, which the vast majority of you probably are. If you're federally regulated, if you're in banking, telecommunications, transportation, things like that, then you're governed by PIPEDA and you have privacy obligations under PIPEDA. If you have employees in British Columbia, Alberta, and Quebec, then you have restrictions around the types of information that you can collect with respect to your employees, which includes, of course, vax status and the testing, the results of their tests. If you have an in-house nurse in any province who's collecting this information and doing the testing for you, then you're caught under all provincial or the applicable provincial health privacy information. Oddly enough, if you have an HR person who doesn't have a medical degree or certificate of any kind, then you're not captured under the provincial health information restrictions. But if you, like I said, if you have a nurse on site who's doing it, then you are. This doesn't mean that you can't do it. It doesn't mean that you can't collect the information. It just means that you have greater obligations. And what that means is you have to have employee consent to do it. And we would recommend that you don't rely on implicit consent, which simply means we require you to test. And so the employee engages in the testing, and therefore you have their implicit consent to do it. What you should do is, as part of your policy rollout, develop a consent form that the employee signs and says, I agree to undergo rapid testing, or I agree to disclose my vaccination status. And then you've got a written consent and you can hang on to that. In terms of maintaining the QR codes and the actual test results, you don't have to keep that. I think there's a misconception by employers out there that you've got to actually maintain that information, or the actual code, the actual document from the ministry, various ministries indicating that the person has been vaccinated. You don't. Once the employee shows it to you, you don't even have to collect it. If they just show it to you, you can destroy it. You can just have a document, a piece of paper or an Excel chart that ticks beside the person's name that they've been vaccinated. You don't have to keep the QR code. If they send it to you by email, delete it. Your obligations are to secure the data that you collect. And so if it makes you nervous that you don't have proper security, then somehow record what it is that you think you need to know, which is just their status. They tested negative, tested positive, they've been vaccinated, have not been vaccinated, and get rid of the other stuff. You have to do it in a way that it's absolutely deleted, destroyed, and anonymized so that there are no security breaches, but then you're covered. Okay, next slide, please. How do you mitigate liability when your customers are saying that they have certain requirements? So we've come up against this with many of our clients who have their business is, service provision themselves, or they have to go out to client sites to do training, repair machinery, that kind of thing. And their customers are requiring full vaccination or testing in order to go into their workplaces. What I will say is that unless there is a reasonable necessity for the person to become vaccinated or test to go into that workplace, a customer's demand in and of itself is not legal justification for you to require your employees to do something. There are, however, I would say, going to be very few situations right now where it would not be reasonable for you to require your employees to become vaccinated or undergo testing in order to enter a customer's workplace. I'm just bringing this up because it doesn't give you a get out of jail free card just because your customer is requiring it. In certain circumstances, we're also seeing that customers are requiring that they be provided with vaccination or test results of the employees who are going to be entering on their site. You cannot provide that information to your customers without your employees' consent. That would be either a breach of their terms of employment, or if you're in a province where there is privacy legislation, it would be a violation of that legislation. So you do need express and informed consent before you disclose that information to any third parties. Informed consent is consent. It means that you disclose to the employee the who, what, where, why, and when with respect to the data. What are we collecting? Why are we collecting it? Who is going to have access to it? How is it going to be stored and protected? And when is it going to be destroyed? Who can I contact if I have questions about the disclosure or collection of this information? You should also try to limit the amount of information that you're disclosing to the least amount possible. So for example, if the customer is requiring the QR code, then you should really be having a very hard conversation with that client and push back and say, why do you have to have the QR code? Can't we just provide you with an attestation that the employee has been vaccinated? And find out why they really need that further information. If they just insist on it, then find out what they're going to do with it after they get it. Are they going to destroy it right away? Because even though, of course, your business wants to keep that relationship with the customer, you have an obligation to protect your employees as well. We also received questions as to what do we do if an employee just flatly refuses to consent with no legitimate reason, and the customer does have a good reason as to why they need the information about vaccination status or testing. In those situations, again, what we're suggesting is that if the employee has no good reason for not wanting to disclose that information, and they're just saying because it's my right, it's my privacy right, then we feel that you will have very low risk if you warn the employee, look, this is going to result in us having to change your duties, which may result in a lower income. You may have to be placed on a leave of absence because our customers just won't let you on their site. And therefore, you are the one that's impacting your ability to be able to perform your duties. Okay, next slide. The next one is dealing with remote working and nomad policies. This really doesn't have anything to do with COVID. It's just become more pronounced as a result of COVID. And what we've seen over the last couple of years with workforces being sent home and having to work from home is the belief by employees that they can just go and work wherever they want in a different province, in a different country. And they don't really have to tell their employer that they've done that because everybody's working from home anyway, and it's all the same. Well, that's not true for you as the employer, and it's not really necessarily true for the employee either, because when you move into another jurisdiction, you engage laws and trigger laws in those jurisdictions that after a particular period of time will now apply to the employment relationship. And those laws could be anything. They're, employment laws, occupational health and safety laws, tax laws, securities laws, if you've got securities plans, all kinds of different things are triggered. And so what we're now advising employers to do, if you're going to allow people to work from home remotely on a temporary basis, you absolutely should draw a written agreement with them. Don't rely on policies alone that says, here's what's going to happen if you go work from home. You should have a signed agreement with the employee that sets out that you can require the employee to come back to the workplace at any time with notice or without notice. You can require the employee to cease working remotely at any time and come back to the workplace permanently. And also, very importantly, that the employee must continue to work for you in the province that you have agreed upon, and that they may not move out of that jurisdiction without your written approval. Unfortunately, we've had circumstances where our clients have found out 3 months later that somebody's moved, from Ontario to British Columbia, and now we have to scramble because the client has no employees in British Columbia, and now they have to get used to dealing with British Columbian law and things like that. If you have a term that says that you can't do that, then of course that could be a ground for termination of employment. You're not obligated to allow them to do that. The final thing to mention is that if you decide to have a hybrid policy or permanent remote workforce now as a result of COVID, because it's helped you've realized that it works, or you've got staff that really enjoy that and you're going to allow that to happen, you still have obligations under the Occupational Health and Safety Act for home workplaces or remote workplaces. Ontario is one of the jurisdictions where there is no exception for remote workplaces. That may come to pass very soon, given how many people are now working remotely. But as of right now, you have the same obligations while they're working at home as you would if they were in the workplace. All right, so that concludes the formal presentation. Hina has created a slide that has information that we've prepared at Gowlings, resources for you with respect to various COVID-19 issues. And I guess we can open up the floor for questions, though I think we're now over time.
I actually think we have this scheduled till 10:30, so we do have a little bit of time for questions, which is wonderful. And I would encourage anyone that would like to, turn on their camera or unmute themselves and ask any questions to step in. There was one received through the chat. I'm going to ask it as it was asked and hope that you might understand a little bit better. But so assuming that someone is attempting to secure document to support their creed grounds, but they refuse to participate in rapid testing, what would you recommend? And Bet, you are on mute currently.
All right. So if I understand the question correctly, they're refusing to become vaccinated because of creed grounds, but there's really no creed-based reason why they couldn't undergo rapid testing. And if you're telling me that the employee is saying, no, my creed prevents me from undergoing rapid testing as well, I don't see how that's possible, and I would deny that accommodation request. So the advice that I would give is tell the employee that fine, we'll accommodate your religious creed-based belief. You don't have to become vaccinated, but you do have to undergo rapid testing. And if you refuse to undergo rapid testing, here are the consequences. And once again, you can place them on an unpaid leave, or you can terminate their employment. There are plaintiff lawyers out there who say if you terminate their employment, you better do it on a without cause basis. Howard Levitt, however, and it's my opinion, and I cite Howard Levitt because he's one of the most pro-employee lawyers out there, he says no, terminate for cause. And I tend to agree with that. I can't say though that don't go around saying, well, Bettina said we could do this, because we don't know yet what the courts are going to do. But, and I've said this 1,000 times in my career, I would be shocked if a court didn't uphold that termination for cause, because the employee's refusal, in my view, is unreasonable.
Thank you. And so we do have a bunch of questions now coming in through the chat. So I do encourage, if anyone does want to ask in person, please feel free to. I am happy to have these conversations as well. This one's an interesting one. So for offices, if we've been working remotely to date, how do employers build a case around the Ontario Health and Safety Act for going back to the office? And they say moving down the order of hazard control, such as vaccination policies, barriers, masks, as being necessary and reasonable. I kind of read that as, how is their case to go back to the office where risks are slightly higher? Because, you're obviously now in contact with other people and where you're not at home.
Well, the Ontario government, we brought a lot of guidance from the Ontario government as it moves to open things up. And when the Ontario government says people can go back to work, then it's our view that you're safe to require people to go back to work, so long as you continue to follow the protocols that are issued by public health. If you veer off those protocols, then you're going to be in trouble under the Occupational Health and Safety Act. But as long as you are vigilant in enforcing those protocols like masking, screening, disinfecting, telling people to, socially distance, that type of thing, then you should be fine under occupational health and safety legislation. There is no requirement anymore that you cloister people at home. You can require them to come back to work now.
Mhm. Thank you. So another question, some of the early requirements for staff who refused the vaccination was to have a formal education session in addition to rapid testing. Is there a formal education session available from either the MOH or the MOL that can be used, or is the employer to create their own?
So that requirement was for organizations or employers who were legislated to vaccinate. So, for example, healthcare, long-term care facilities and things like that, who were required to implement vaccination policies. If the employee refused to become vaccinated, they are required to undergo an education session. That, and Hina, correct me if I'm wrong, because you know the legislation better than me, that's not required in all workplaces right now, the education session, though it is a very good idea to require, you can require employees to do it. And I do believe, Hina, again, you know better than me, there are videos that have been put out by the government, are there not?
Yeah, so when the government released Directive 6 around, hospitals, long-term care homes, one of the requirements was to make available an education session. The Directive 6 goes through what should be in an education session. So, with the aim of the employer providing it themselves, but there's also an accompanying document that provides some links. So it has links to videos, it has links to different, like I think there's a 12-part session in one of them. There's no one particular education session that's endorsed by the government. So it's not like directly from the Ministry of Health or the Ministry of Labor, but there's a full page of resources that the government has provided that employers can look through and kind of choose which one they want for their workforce.
Thank you. Another great question here is, if two employees share an office, can we allow them to remove masks when they are both vaccinated and seated at their desks more than 6 feet apart?
I actually don't know the answer to that question. Hina, do you know?
Well, if you're following all of the other public health requirements, I mean, if you're 6 feet apart, I want to say yes, but again, that's a good question because they're two employees, not from the same household. I guess if you can maintain the distancing, I'd be more comfortable with taking off the masks. But yeah, that's a good one.
That's something, Jeff, can you make a note of that question? We can look into that and see if we can find an answer. We may not be able to. Maybe one of those things that just falls under is it. Are you still taking reasonable precautions under the Occupational Health and Safety Act? In my view, I would be okay with that on that ground, but we can look into that to see if there's any legislative requirement to maintain masks.
Okay, wonderful. I'll certainly make a note. I'm trying to go back to the question and see if they put it publicly or not, and invite that person to certainly reach out to you, though, who the asker of that question. Please do feel free to reach out directly.
Thank you.
There's lots of good ones. So here's one about our workplace has two unions. One has taken the position that they must be vaccinated and all the members have done so. The other has taken the stand that employers are not required to be vaccinated. They say we have most employees that have been vaccinated, but two remain unvaccinated. And they've been reluctant to implement a vaccination policy to date. But there wasn't a question there, but a specific question, but I guess it's kind of, how do you recommend they navigate around that?
Hina, you had mentioned the case that came out. It was the hospital. No, that was the injunction case. There was a case that came out recently where a union grieved a vaccination policy, and they were shut down. The labor board held that the vaccination policy was reasonable. I'm right about that, right, Hina?
Yeah, it's ringing a bell. There's been so many
Yeah.
of these little cases. Yeah.
It was in the last couple of weeks that the decision came down from the labor board. I can't remember exactly what union it was, but the objection, of course, was that it was overreaching in terms of the general management provisions in the collective agreement. And the labor board held that no, having a vaccination policy was not in violation of the collective agreement. And I think we're going to see more and more decisions like that. So again, while I can't guarantee that your union isn't going to be successful, I think that they're going to have a hard time, especially if you have other unions in the same workplace saying, no, we think that this is the right way to go.
Wonderful. I've now received some comments about that masking question, and 2 people in an office saying that there's a number of people that would be interested to hear that answer. So maybe we'll try to get an answer in time when we send out a copy of the presentation. We can have that included. There's one individual that's asked this question twice, so obviously really wants it answered. The question is, can you require an employee to undergo rapid testing if they are working from home? I personally am struggling to understand why that would be necessary. So I'd invite that person to come online if there's more to it, but maybe you know of a reason why that might be important that I'm missing.
I agree with your position. I don't know why you would require an employee who's working at home to undergo rapid testing unless they were going to be coming into the workplace. If they're not coming into the workplace, I don't see why you would do it. And if you took adverse action against the employee for refusing to produce rapid testing results under those circumstances, I think that there's a much greater chance that the employee would be able to bring a successful constructive dismissal claim. Like you, Jeff, I'd like to know what the rationale is for requiring the testing.
Right. One example of a rationale might be if that employee is required to go to other work-related sites, they might want a rapid test before that particular event. But overall, exactly what Bettina said.
Yeah.
I'm struggling to keep up with all these questions right now. This is wonderful. Here's one. We have a couple of employees that are not vaccinated due to personal preference. As an employer, do we have a right to accommodate them at all to return to office?
You may require them to return to office, and you have no obligation to accommodate their personal preference. So those 2 points are for sure. However, if you don't offer rapid testing as an alternative, and you then say to them, well, you have to come back to work, and in order to come back to work, you have to be vaccinated, full stop. You're going to be placed on a leave of absence, or even more severe, we're going to terminate your employment. You may have to pay the employee out. The employee may have a constructive dismissal, a successful claim. You may have to pay them termination pay because you didn't offer the alternative of rapid testing. We don't know yet because we don't have a decision.
And you know what, on that point, there's a question here, like if an employee refuses to get vaccinated and doesn't have a medical or CREED exemption, do you recommend that allowing them to continue with rapid testing should be considered first before placing on unpaid leave of absence, or they're not compliant with vaccination policy? So really, should the rapid testing be the first consideration before placing on leave?
The least risky approach for the employer. So you offer rapid testing. That's the least risky approach. If you want to take a less conservative approach and say, nope, you must be vaccinated, otherwise you're going to be placed on an unpaid leave of absence, then there is some risk for you. We don't know yet what the courts are going to do with that.
And you know, a great kind of follow up to that is if a company offers rapid testing for approved human rights reasons, do they then also have to offer rapid testing for those who are just not, you know, out of personal preference choosing not to be vaccinated?
No, there's no reason why you have to offer rapid testing just because you offer it to people as an accommodation who have legitimate human rights complaints. But again, I go back to the point that if you don't offer rapid testing to everyone who doesn't want to become vaccinated, there simply is a risk that a court could find that you are not being reasonable in the terms that you're now imposing on your employees. Unfortunately, we just don't know until we get a case from the courts on this.
Great. There's some other comments about that, the masking in an office as well, because of meeting spaces and things like that, where, you know, trying to get people. So it's not just two people working together. It's also when people are in a meeting space, you know, how to keep everyone safe. Here's a good one as well. What about the situation where we have employees and also tenants in our building? Our employees are all double vaxxed, but the tenants' employees are not all double vaxxed. I guess the kind of question is, you know, who's that responsibility on? And, you know, is it on the sort of landlord? Is it on the, I'm assuming these are employees of another company that leased out some of their space. Who does that fall to?
Right. Well, landlords have obligations under different legislation and do employers. I don't specifically know what their obligations are in terms of, you know, ensuring that all of the tenants are vaccinated. They would have obligations to ensure that the tenants are complying with public health requirements. But there's no legislation yet that, depending on if you're in the healthcare industry or something like that, but if we're talking about an office, a general office building where, you know, you've got, say, a law firm, you've got an accounting firm, you've got a tech company in there, there's no obligation yet in legislation that says that everybody has to be double vaxxed. So just because the landlord is allowing tenants in there who are not double vaxxed does not mean that they're violating any laws. They still have to comply with other requirements like screening, masking, disinfectant, that type of thing.
Wonderful. They're one of the attendees. I think it's more just a statement to one of the other questions just mentioned, that an unpaid leave of absence could be constructive dismissal as well, and that it would be better to offer them a reasonable alternative employment that includes compliance with the company's vaccination policy.
Yeah, no doubt.
Yeah.
Unpaid leave of absence absolutely could lead to constructive dismissal. It's the, again, we were talking about steps of liability. It's less risky than terminating employment. So you place them on an unpaid leave of absence, for sure you have some risk of a constructive dismissal claim, but a court, remember, when you're imposing disciplinary action against an employee, it doesn't automatically amount to constructive dismissal. The court looks at the disciplinary action imposed in the context of the situation to determine whether or not it's proportional. Mm-hmm. And so a court may very well find that under these circumstances, an unpaid leave of absence is a proportional disciplinary measure.
Thank you. And you know what, because of time, I'll make this the last question. It's I think, a pretty straightforward one and a good one to end on. Can businesses require people visiting their office to be fully vaccinated?
Yes.
Yeah, that's the answer I kind of thought. Wonderful.
Of course, you have to comply with human rights.
Of course. I think I made it through all the questions. My apologies if I did miss, for anyone that's on the call, if I did miss one. I would highly recommend, if your question was missed or if you have one that you didn't ask or didn't have time to ask, please feel free to reach out to either of our presenters directly. Within the presentation that we'll send out has their contact information, but you can also find it online at gowlingwlg.com. I thank everyone for being with us today. We will send out a copy of the presentation and hopefully also have an answer to that to the masking question within an office space. So thank you everyone for joining us. I appreciate it, and I hope you have a great rest of your Thursday.